cause number DC 2002413, Leslie Shigaris on behalf of GMX Marketing LLC. And with me also is Joel Reese.
Okay, Mr. Durst.
Good morning, Your Honor, and everyone. This is Tim Durst from Baker Botts, representing Stusco, the defendant in this case. And with me this morning and presenting argument for Stusco is my colleague at Baker Botts, Christopher Hunt.
Okay. All right, so let's just talk briefly. It's a relatively narrow motion that we're dealing with today. Mr. Hunt, why don't you just discuss with us what is the scope of the dispute here today?
Sure. So our motion actually has two issues in it, but I believe only one of them is actually in dispute. So the first issue is the use of depositions from the Whiting litigation and the related case. And the parties are in agreement that the GMX witnesses and the Stusco witnesses that were deposed in that case, that those are going to come over to this case and be used in accordance with the rules, with the Texas rules. And GMX's proposed language in their response to our motion, we're okay with. It basically just says the Whiting depositions are going to be dealt with separately. So that's, and if Mr. Garris agrees, I think we're fine just adopting the language that they have in their response.
Judge, we made it so easy for you. We agree.
Yeah. You're muted, Your Honor.
What is in dispute then?
Okay, so then there's one more issue in dispute, and that is whether or not there should be any limitations on the number of hours for depositions on each side. And here's Stusco's position. Given the unique nature of this case, we believe limiting depositions to 36 hours per side is reasonable for two reasons. First, GMX has conducted significant discovery into the facts and issues related to this case in the Whiting litigation. And two, the issues in this case are relatively limited and defined in nature. This is a breach of contract case about whether or not Stusco validly terminated a contract with GMX. And I'll note that while GMX has had the opportunity to conduct significant discovery into the facts and issues in this case, Stusco has conducted no discovery at all. Stusco is the party that is playing catch up here. And Stusco believes that it can catch up to GMX's significant head start and develop the facts necessary in this case within the confines of the reasonable 36 hours per side limitation that it's proposing. And given the fact that Stusco is the party playing catch up and is bearing the brunt of, uniquely bearing the brunt of fact discovery in this case, Stusco's view on discovery limitation should be afforded substantial weight. And just a couple points I wanted to make. First, as we stated, the parties are in agreement that the GMX and Stusco depositions and productions from the Whiting litigation are going to come over to this case. So we already have a substantial factual record as our starting point. This is a unique case where we're not sort of putting on limitations as we start from scratch, where there's no discovery. We have a large factual record that we're starting with here. And as I said, this is a breach of contract case. GMX apparently agrees in their motion for summary judgment that they filed last month. They framed the issue as under the four corners of the contract that issued, did Shell have a right to terminate GMX's contract? And we agree that that's what this boils down to. It's a breach of contract case. There's a substantial evidentiary record, again, illustrated by the fact that GMX filed a motion for summary judgment before discovery even started in this case and attached a 300-page appendix to it. So there's been substantial discovery already into these issues. The issues are relatively defined and limited in nature. So it's our position that 36 hours, and to be clear on our position, we're saying 36 hours per side and deducting from GMX's side the hours that they spent with Stusco witnesses, which was 14 hours in the Whiting litigation. We feel that is more than enough to develop the facts in this case. And again, Stusco is the party that is really going to be bearing the brunt of discovery since it's conducted none at this point. So we feel that we can develop the facts necessary within those limitations. You're muted again, Your Honor.
Shigaris. So kind of tell me why you need more time than this.
Thank you, Aaron. I think you froze, so I missed the first part of what you said, but here's the situation. One, this is a level 3 scheduling order. We have tried to reach agreements with the other side to narrow issues. As noted in their motion and our response, we agreed to limit the number of requests for production. We agreed to limit number of interrogatories. We've agreed to pull over certain depositions and documents. But quite frankly, in a level 3 scheduling order, I have never seen a court limit the number of deposition hours absent an agreement by the parties. But I think here the reason we need more time is, like Mr. Hunt just mentioned, we're at the beginning of discovery. While we have taken certain depositions, we've taken 4 depositions of Shell witnesses in the prior case. Those were limited to partial depositions. If you recall, we were splitting our time with Whiting, and so we didn't take full depositions of those witnesses. Additionally, although there is a large overlap in the issues in the case, you'll recall, Judge Hoffman, in the Whiting litigation, at some of the hearings, we discussed whether or not JMEX actually needed to prove that Shell breached the contract for our tortious interference claim against Whiting, and that you indicated, and we agreed with, that that was likely not something that we had to prove in the Whiting case. So while there's a lot of overlap, the depositions are slightly different because there's legal issues and factual issues we didn't have to establish. And lastly, Your Honor, we took these depositions in a very different legal market, I guess, and the global pandemic hadn't hit. And so there's a number of depositions we took, like I said, that were partial depositions that were for discovery purposes, on the fact or assumption that some of these witnesses would be available at trial. That no longer is probably going to be the case. And so there are witnesses that we need to go back and finish depositions with that we didn't complete our hours with. And we've just now received the disclosures from Shell this week. And so to limit the depositions on the front end, I think would be premature, and I think create a potential issue down the road. We're both sophisticated firms. We don't waste time. We don't take unnecessary depositions. And of course, as we move through discovery, if we start noticing depositions that Shell believes is out of line or it's too much or burdensome, they can always file a motion to quash and we can deal with it at that time. But to say on the front end, on a level 3 scheduling and discovery case, that's where there's a $50 million dispute. When we tried to have this case tried this year, Shell said, no, we can't try it until 2021 because of the amount of discovery that we need to take, I think would just unfairly prejudice the parties at this time.
The one part of it, I kind of disagree with you, Mr. Garris. I've had a number of level 3 cases where the parties have differed on the amount of depositions or the amount of deposition hours that are needed, and I'll have to make some kind of determination. And so I don't think that's unusual. I've probably seen it a couple dozen times as a judge. So the question in my mind is, and this is such an unusual procedural posture for the case, because we had this other case that, as I've said a number of times, I thought should have been all together in one case, but we decided to piecemeal this. So, I do think that given the procedural posture that we have in this case, and the fact that Stutzco wasn't, or Shell wasn't a party in the original case, so they were at kind of a disadvantage, that you have a different amount of hours for each case, given that fact, is not unreasonable. So, but I don't know that 36 hours and 22 hours is the right amount. So, Ms. Shigaris, what are your thoughts as to the right amount?
I think, Your Honor, we would need probably 40 hours on our side of new deposition time, given kind of the witnesses that we've identified. So it might be easier to just say we get 40 hours, however we use them with witnesses, whether they're witnesses that were completing or new witnesses. And that, I think that would make JMEX, obviously have to be efficient with the time that we use. And that way there's not some future issue down the road. We get 40 hours. And if that means Shell needs 50 or 55, it makes no difference to me, because I don't think there should be a limit, but I think we need at least 40 hours.
Mr. Hunt?
Well, Your Honor, 40 does seem like a lot. I will note so far in this case, Jamex has asked for deposition time for 4 witnesses. 3 of them have already been deposed, and we've received requests for production that are almost identical to ones that we've already responded to a subpoena in the other case. So I think 30, I guess 30 hours with the understanding that, we're gonna, Shell will have will have more time than Jamex, given the fact that they've spent 14 hours with our witnesses and that's coming over. We got to make sure that that's accounted for, that we don't want to each have 30 hours and then they get in effect 44.
That's fair. What I'm going to do is plaintiffs will get 36 hours, defendants will get 50. All right. Anything else we need to chat about?
Yeah, Your Honor, as Ms. Shigaris noted, the parties have agreed to limit discovery, so 50 requests for production, 30 interrogatories. That's not memorialized in anywhere. The parties have acknowledged in their briefing that they've agreed to it, but it's not in any order. So I think it might make sense to include that in this latest order.
No problem with that. Can you guys give me an order that memorializes what we've discussed today?
Yes, Your Honor.
Yes, Your Honor.
Guys, anything else we need to chat about?
Not on our end, Your Honor.
We're good.
No, thank you.
All right, Mr. Reese, Mr. Durst, grace to see you guys, Ms. Shigaris, Mr. Hunt. You guys, I hope you have a safe weekend, and we'll see you soon, I'm sure.
Thank you all. Have a good day.
Thank you, Your Honor.
You have a good day. Mr. Williams, I think we're here for the 9:45. Is that correct?
Yes, Your Honor, that is correct.
So there was a bankruptcy filing. It was kind of last minute. What is going on here?
Yes, Your Honor. With respect, if I may address the bankruptcy issue first, if that's okay with you, or
No, I think that's necessary. Yes, absolutely.
The bankruptcy issue. Short answer, I'm not entirely clear. I received the same email that the court did yesterday from counsel who is not present, saying that the plaintiff filed a bankruptcy proceeding. Oh, Your Honor, can you hear me? Or am I?
Yes.
Okay. I received an email, the same email that the court received yesterday, saying take all hearings down. The plaintiff filed bankruptcy the previous day. I, however, have not received any sort of formal notice. There's been no suggestion of bankruptcy filed, which I believe, Your Honor, is the very first thing you do when a bankruptcy is filed is to file suggestions of bankruptcy in any other court. But more importantly, this is not our lawsuit. We did not file this lawsuit. Mr. Hoffmaster is the plaintiff. This is his case. I'm just defending it. So unless and until some sort of formal notice other than this counsel's word, which if the court would like me to discuss the veracity of his words in the past, I'm happy to do.
Yeah, this case has had an interesting history. I'll just say that. But
yes, Your Honor.
So obviously we're in kind of a difficult spot here. We have a number of interns watching. Best practices is clearly to file a suggestion of bankruptcy. That would make this all a lot simpler. This emailing of a bankruptcy order, Rhonda, can you check the file to see if he did file a suggestion of bankruptcy? We maybe just haven't gotten it yet.
Nothing. I have not received any notification of service or anything like that. I know that question was posed to me, Your Honor, but for what it's worth.
It's okay. Let me make. She sometimes will get stuff a little quicker.
If
so.
I may.
Oh,
And I'm sorry, my internet connection.
Yeah, she said we have received a suggestion of bankruptcy. Let me see if I can find it.
Nothing has been served on our side, and nothing in the court's Dallas County portal docket is notated as to any filing or anything of that nature, nor is counsel present, I may add.
No, I understand.
Your Honor, may I make one comment that may be helpful?
What's that?
With respect to today's hearing,
Mm-hmm.
and with respect to the relief it requests, it is not any effort to collect a debt or enforce a debt. It is the relief requested in the present motion is simply a briefing schedule, and that briefing schedule, by and large, relates to non-monetary relief or in relief that is not the enforcement or collection of a debt. And as the court well knows, any sort of automatic stay that any bankruptcy court would impose would not relate to the matters I'm discussing today with the court.
I was mistaken. She is said that we don't actually have a suggestion of bankruptcy. She was just referring to the stuff that was emailed.
Your Honor, I apologize. I lost you.
My court coordinator said that we have not received a suggestion of bankruptcy. I was mistaken. It was just she was referring to the email she sent me about that you received with that information. But anyway, so let's. I mean, it's a difficult spot because we do know that they're claiming there's a bankruptcy. And what was set today? A motion to vacate what? The arbitration award?
No, Your Honor. The only thing set today is on my motion to set briefing schedule. There's a number of, it's not seeking any relief. At least on my end, all I'm trying to do is given the COVID-19 pandemic, the district court's March 6th standing order regarding live hearings and the restrictions on in-court testimony, and three, perhaps less importantly but still relevant, is the district courts of Dallas County's April order regarding page limitations, appendices limitations, and motions for.
I'm not typically very strict on that, so don't worry about that. What I would suggest we do, just because this doesn't seem terribly urgent, is to why don't we kind of get clarification on this bankruptcy, and do you want to reset this in a week or something?
Well, Your Honor, we have another hearing set for Monday, and we were actually the primary purpose of this motion, which we've been trying to see if we could have a conference with the court for a couple of weeks. The other side has been objecting.
Okay.
But there are several things that, primarily just because of the COVID-19 issue, we have a Rule 692 motion to enforce and/or motion for contempt for violations of the temporary injunction. I know that there's a lot of chatter throughout this case on that issue, but the arbitration panel that was chaired by former Justice Deborah Hankinson found that the temporary restraining order was violated by the plaintiff while it was in place. The temporary injunction that was entered by this court on April 6th, 2019 was violated and remains in violation as of the date of the arbitration award and poses, and the plaintiff poses a high risk of violating it again in the future unless additional remedial action.
So, Mr. Williams, why don't we do this? Why don't you research the issue and talk to your opposing counsel about, are they going to file a suggestion of bankruptcy, and is there actually a bankruptcy that's been filed? And then let's talk about that on Monday.
I apologize to say this one more time. I lost you again. I'm very sorry.
No, what I said is, why don't we discuss that on Monday? In their interim, if you could find out if your opposing counsel is going to file some type of suggestion of bankruptcy, and then maybe you could confirm with the bankruptcy court, has this actually been filed? So we have a little bit better understanding of what's going on. All right, Mr. Williams?
Yes, Your Honor.
We'll see you on Monday, okay?
Thank you, Your Honor. Have a great weekend, and interns, have a great weekend yourself.
You too.
Thank you.
Okay. So let me just give you guys a quick warning. We have two people in the waiting room. One of them says anonymous, which makes me a little bit nervous. I don't know why that is. So it could be a situation where we could have a Zoom bombing. I'll try to, so with those, you never know what could happen. And so I apologize in advance. I don't know what this person is doing or who they are, but I feel like I need to let them in. So hopefully it's just somebody who hasn't changed their name, but
Judge,
just
you're also still on
what?
YouTube. You're still streaming on YouTube. I didn't know if you wanted to stop that.
No, that's okay. I'm just going to let them in.
Hello.
Hello,
Hi.
guys. Hello.
Judge.
Can you hear me okay? There's someone on here named Anonymous. If you could put your actual name on here so we know who you are. That's one of the people we just let in. Does anyone know who he is?
This is Tori. Do you see me?
I see you, Tori Levine, Jordan Whitten, and then, okay, Rich Hyde. Sorry, we were worried we were about to be Zoom bombed, so I apologize.
You might still be, Your Honor.
Okay, great. That would be fun. I haven't been Zoom bombed yet. So, my understanding is the 10 o'clock hearing was one of the 10 o'clock hearings just settled. So which case are you guys here on?
Scott Mann.
Versus Texas e-cigarettes?
Yes,
Your Honor.
and we've submitted an agreed order to transfer venue to Tarrant County.
Okay. Is that what's set today?
No, Your Honor, this was a status conference, but there was some confusion after we submitted the order, and so Rhonda asked us to show up today.
Okay, so I see that here. So that's been agreed to by all parties?
Yes, Your Honor.
Okay. All righty. So I'll go ahead and sign that. Let me just see real quick. And this was going to be a scheduling conference just to figure out. Okay. Let me look at this real quick. Is this the Suicide Bunny case? Is that the same case?
No, Your Honor.
Okay, we have another e-cigarette case. I call it the Suicide Bunny case because they're one of the defendants.
I was dismissed out of that one. Yes, I know.
Okay, so this is a different one. Oh, okay, so that's interesting. There's a second one. Okay, and this one is going to go to Fort Worth. Okay, all right. Well, I'll get that signed hopefully by the weekend, and we'll get you the order next week. Okay.
Great. Thank you.
Okay. Thank you.
All right. You guys have a safe weekend. Okay.
You too.
Your Honor.
All right. Goodbye, guys. And Mr.
Bye.
Whitten, are you on that case too?
No, Judge, I'm on In Re Madison title. We also have a 10 o'clock setting.
Out for a second there. What case are you here on?
Sorry, I lost your audio there. What were you saying?
What case are you here on? You cut out for a second.
Oh, sorry. In Ray Madison Title Agency.
Okay. I thought that case settled. Is that not settled?
Well, I filed an agreed order to continue this hearing because I think we're settled. They just sent me a flash drive full of stuff to try to settle it, and I hadn't had a chance to go through the 1,000 documents. So I'm hopeful that once I go through that, we can drop the case altogether. But Rhonda asked me to show up because we, I guess, didn't get the order signed continuing in advance of the hearing.
Okay. Let's see. So do you want to just pass the hearing, or what do you want to do?
Well, what I asked opposing counsel for, since we had to effect service for the show cause, is for him to agree for your honor to sign an order continuing to hold him under subpoena for the continued hearing.
Okay.
So that's why we submitted an agreed order to try to keep him under subpoena so I don't have to serve him again if necessary.
And when did you email us that order?
It would have been the 18th.
The 18th. And did you, Rhonda, you emailed Rhonda that order?
I don't know if I emailed it, I e-filed it, but I'm happy to email it right now if you'd like.
Yeah, if you could email Rhonda the order just to make sure, and Rhonda, if you could print it out and put it on my chair.
Okay. I will do that right now, Judge.
All right, Mr. Whitten, is there anything else you need today?
That's it, Judge. It's good to see you again. It's been a while.
Yeah, it's great to see you. You want to, let me have all the interns introduce themselves.
Sure.
Miss Randy, if you want to start.
Good morning. My name is Randy Williams Keller. I'm a rising 2L at SMU Dedman School of Law.
How's it
Mr.
going?
Bolo?
I'm an
Good
SMU
morning.
guy as well.
All right.
My name is Caroline Rombolo. I'm also a rising 2L at SMU Dedman School of Law.
We have a few here today. Mr. Hidari.
Morning, my name is Michael Yadari. I am a rising 2L at Texas Tech School of Law.
Nice to meet you.
Mr. Asani.
Continuing on the diversity of schools represented here. Good morning. My name is Samir Asani. I'm a rising 2L at Texas A&M.
Ms.
Cool.
Cox.
Good morning, I'm Nicole Cox. I'm a rising 3L at SMU.
Nice to meet you.
Mr. Taylor.
Good morning. My name is Gage Taylor. I'm a rising 2L at SMU.
Nice to meet you.
Ms. Campbell.
Good morning. I'm Kayla Campbell. I'm a rising 2L at St. Mary's University.
Nice to meet you.
Ms. Cornelius.
Good morning. My name is Sejnia Cornelius, and I am also a rising 2L at SMU Dedman School of Law.
We have a few SMU people this year.
Sounds like it.
Good morning. My name is Stephanie Church, and I'm also a rising 2L at SMU Dedman School of Law.
Nice to meet you.
All right, Ms. Cervantes.
Good morning, my name is Amanda Cervantes and I'm a rising 2L at Texas A&M School of Law.
Nice to meet you.
Mr. Young.
Good morning. I'm Duranius Young, and I'm also a rising 2L at SMU.
Nice to meet you.
Ms. Balderrama. Are you still there?
Yes. Good morning. My name is Alexa Balderrama, and I am just like 90% of this group and am a rising 2L at SM Dedman School of Law.
Well, nice to meet you as well.
Ms. Orbadon.
Good morning. My name is Leela Orbadon, and I'm also a rising 2L at SMU.
Nice to meet you.
Nice to meet you.
And Ms. Harrison.
Good morning. My name is Camille Harrison, and I am a rising 2L at University of North Texas, Dallas College of Law.
Nice to meet you.
Okay, Mr. Whitten, why don't you tell them just a little bit about where you work and what you do?
Well, like I said, I went to SMU. I graduated in 2014, and I've worked at the Taylor Song Law Firm since then. I've worked here my entire career. I do mainly commercial litigation, but occasionally Judge Hoffman will see me for a personal injury case or something of that sort. But for the most part, we do contract disputes. On the defense side, we represent businesses that get into contract disputes with other vendors.